Namaskar to all of you in the series of Learning the Law, which in my YouTube channel. So, I will be today discussing about the provision as given under the Protection of Women from Domestic Violence Act of 2005 in India. So, just to start this uh, disclaimer that I am law graduate from the Faculty of Law, University of Delhi. So, I'm presenting this uh, act before this learned audience. Okay, so the statement of purpose and objective behind the enactment of the Protection of Women from Domestic Violence Act of 2005 as given under the act is to provide for effective protection of the right of women guaranteed under the Constitution of India who are victims of violence of any kind. So within the context of family, this act was enacted like effective protection of the right of women because there are constitutional protection given to the woman like article 15 subclause clause 3 of the constitution of india gives the state power to enact legislation for promotion and protection of the women and children. So that's called positive discrimination within the right to equality. So other also constitutionally guaranteed principles are there, like fundamental rights are there. So for effective protection of the right of women, this act was enacted in year 2005. As per the statement and object and reason given into the act, it says that domestic violence is a human right issue. So what is human right? As per India, there is a Protection of Human Right Act of 1993. So under this act, the human right has been defined, which are enforceable by law. And these are human rights. So domestic violence is the human right issue because serious deterrence to development it happens when domestic violence to the woman is caused. And India, because there are Vienna Accord of 1994, there is a Beijing Declaration, and there is also a platform for action. Uh, these all international body has come, and there is a UN that's SADO. They will say UN Convention of Elimination of all form of discrimination. So uh, uh, these all are general recommendations of the UN are there. So where the state party, state into sense, India is the state in that international law per se. So a state party has said that they have to act to protect women against violence of any kind, and especially within the familial context, the violence was happening. So it was agreed in the shadows that we will be protecting. And as per the law protecting women is concerned in India, the Indian Penal Code, Section 498, capital A of is there, which protects against the husband or the relative who are doing the cruelty. So these all remedies are there. Also, there is a like as I said that Article 15 is there positive discrimination. That means equality before law and equal protection of law. There are two facets of right of equality under Article 14. So, Article 15 empowers the state to enact law for betterment and development. So, that is one. And also, there is Article 21, right to life. And time and again, the Honorable Court says that is not only the mere existence, it has to be dignified. So, Article 21 also enshrines some of the like gives some of the right to the woman. And there are also remedies available as section 125 of the criminal procedure code of 1973 gives right of maintenance. So these all are framework and other laws are there. But why the domestic violence act was needed, if you see why this was enacted. So we have to see what is the coverage of the act first, because I said the protection of women from domestic violence. So before that, to understand what is domestic violence, we have to see this act covers which kind of familial relationships. So as given are like who are or have been in relationship with the abuser, the woman, and both party had lived together in the shared household. Okay, they can be related by consanguinity. What is consanguinity? By the relations. Okay, and marriage is also one of the way when people connect with either each other, and the parties has lived together in the shared household. Okay, that is covered. So there are certain relationship, not marriage, but in the nature of marriage, supposed to say live-in relationship. So these all are covered, or through adoption also one can connect, or live together in the household. So these all has been recognized with this act. And even those women who are sisters, women who are widowed, women who are mothers, single women, or living with the abuser, they all has entitlement of legal protections under the DV Act. We'll say in short, Protection of Women from Domestic Violence Act. In short, we'll say DV Act. So, uh, bill also enables the wife or the female living in relation in the nature of marriage to file complaint. Okay, so against any relative of the husband or any male partner, because in the nature of marriage also it has covered. So other important thing is does not enable any female relative of the husband or the male partner to file complaint against the wife or the female partner. That is also has to be understood in detail. Okay, also there are like mm, definition of the terms like domestic violence, which includes the actual abuse or the threat of or abuse, that is like many way, like physical abuse, sexual abuse, verbal abuse, taunting another, emotional abuse, economical, financial abuse. So that all abuses are covered under that definition of the domestic violence. And also there are other harassment also, like uh, dowry, relation to dowry. So Dowry Prohibition Act of 1961 has prohibited the dowry, but there are harassment. As there is a section 304 capital B of the Indian Penal Code which says that dowry debt. So they have given in detail what is actually dowry debt. So they have given like within the 7 year of marriage. Okay, husband or the relatives subjects the woman to cruelty. Okay, and demand of the dowry related demand and harassment was there, and the death is also by the bodily burns or not under the normal circumstances. So the presumption of the law is there that this is dowry death, and the husband or the relative has to prove that it is not dowry debt. So there is a provision in section 304 capital B of the IPC. Also, there is a separate special and local laws as NCRB, National Crime Record Bureau language says. There is Dowry Prohibition Act in India of 1961, which clearly defines the dowry, and how Stridhan is different for that. It is not dowry because it's for exclusive purpose of use of the wife, woman in marriage. So, this is there. So they have covered this all. It's also the housings. There are like shelter needs, like paying rent and other needs are there when there is family relations, and there are some issues are there in family relations. So there are housing needs of the aggrieved person is there. So that also has been covered under this act. So it provides for right of woman to secure housing, to reside in her matrimonial house or share household. That rights has been given there, or residence orders are there which can be passed by the magistrate. So for the purpose of the protection of women from domestic violence act, we have to understand the magistrate here means only judicial magistrate first class or the metropolitan magistrate who is competent to try the offences, is not referring to any executive magistrate here as a magistrate. So that has been defined in coming section. We will be deliberating which particular section defines the magistrate also under the act. So it also empowers the magistrate to pass protections order. So many times police protection from the abuses is needed. So in favor of the aggrieved person, to prevent like any kind of injury or committing or attempt to commit any kind of offenses against the aggrieved woman. So the prevention is needed, and also there is a some of the kind of protection that the place where the woman works, aggrieved woman works. There are also communications. Through communication, the party can victimize. So that also like stopping that kind of conversations, passing that all is given under this act. Also, this act is good in the sense there are provision for appointment of the protection officer and the counselor also, and there are certain service providers, they have used the word. Many of the non-governmental organizations has been their process has been laid down in the act, how to register as a service provider, and after service provider how they can help the aggrieved person, that also has been elaborately laid down on this act. So we'll go into the main act. What is the definition, main provision we will be reading? What is the definition of the aggrieved person? You will go to section 2, small a. Aggrieved person has been defined under this act mean any woman who is or have been in a domestic relationship. So there is need to understand domestic relationships also. So what is domestic relationship? So we will be coming in coming definition clause with the respondents. So we are saying that one is the aggrieved woman. So if aggrieved woman is complainant in the act, so some person has to be respondent also. Okay, so respondent word with the respondent, and who alleges to have been subjected. That means there is allegation of subjecting her to any kind of domestic violence. So domestic violence also definition is very important to understand what is agreed person by the respondent. So the respondent has done so. So another important things, child for this purpose, uh, as many legislation is under the age of 18 years will be considered as a child, and it includes all adopted step or the foster child. All kind is included within the definition of the child. There is compensations order are given under the act. There is a custody orders are given. Custody into say child custody. So there is a domestic incident report or DIR has been defined, that is the report prescribed form. So there are, because not only act, there are rules under the act. So they have given the forms. So domestic investigation report or DIR has certain performa. So we will be deliberating on that. So receipt of a complaint of the domestic violence from the aggrieved person. So as like any offenses, the information or the complaint has been received. So same way, complaint and the information can be received under the domestic violence, for domestic alleging of the domestic violence. So that also has performa. Also, there is something called domestic relationship. As I said, that to understand wholly the who is aggrieved person, we have to understand what is domestic relationship. As given under the act, mean a relationship between the two person who live or have at one point of time in past also lived together in a shared household when they are related by any means. I said consanguinity is there, marriage or through a relationship which is of the nature of the marriage. Okay, and the last is by adoption or any other family member living together in the joint family, because India has joint family system also. Many people live in share household, they live in joint property and joint award of residence. So that also is called a domestic relationship. So after that clearance, so domestic violence under Section 3 has been defined. So dowry, I said, Dowry Prohibition Act of 1961 has clearly defined what is dowry. So that definition is uh, like applicable in this act also. So magistrate, as said, because Section 2, Clause I of the Protection of Women from Domestic Violence Act of 2005 defines what is magistrate. So, magistrate means judicial magistrate of first class. If one is interested, they can go to section 6 of the CRPC of 1973 Code of Criminal Procedure, which says that classes of court, and out of that one class is the judicial magistrate of the first class, and that is the magistrate meant here. And if it is the metropolitan area, I mean 1 million or 10 lakh, and that is what is defined their metropolitan area. So it is more of like census wise declared. So place wise it can vary. Metropolitan area has to be decided by state government. If that area local jurisdiction magistrate is there, city is there, so he will be called metropolitan magistrate. So magistrate in the DB Act in metropolitan area city will be called as metropolitan magistrate under that. And who is like as recognized under CRPC, I said, no, he is exercising jurisdiction under the Code of Criminal Procedure of 1973, and where in the area where the aggrieved person, as I defined in domestic relationship, who arises to have domestic violence. So that person, aggrieved person, wherever she is residing, temporarily or otherwise, or the respondent is residing, that means the opposite party of the domestic violence is alleged to has been taken place, can be the area metropolitan magistrate or the judicial magistrate of first class, whichever is applicable will be magistrate. So there is something called medical facility. What is medical facility? Means such kind of facility which government declares to be medical facility. And also under the act, monetary reliefs are also given. So what is monetary relief under the act? They have clearly says that compensation which the magistrate may order the respondent to pay to the aggrieved person, and as a result of like to meet the expenses which are as a result of domestic violence done by person. So protection officer, I said, because there are state government has to appoint those officers called as protections officers. So there are certain residence order are granted. So under section 19 in detail we'll be reading. So respondent mean, because as an aggrieved person also we read what is respondent in this act mean. Respondent mean any adult male who is or has been in the domestic relationship as defined earlier with the aggrieved person, against whom the aggrieved person has in the nature of marriage, may also file. Aggrieved wife or female live in relationship in the nature of marriage also file a complaint against the husband or the male partner, that is given. Okay, so that is regard to some of the definitions. Shelter home also will be notified by the government. So we'll come directly to the chapter 2 of the act. It says talks about domestic violence. So we have to understand the definition of the domestic violence as given under section 3 of this act, which says that for the purpose of this act, so so because any crime there's something called mens rea and actus rea, that's basic thing. So basic things, the physical act also, and Indian here the omissions are also part of omission and commission are the act. Okay, if the person is failing in duty or he is actively doing something which constitutes the crime, so both are uh, or conduct of the respondent. So the conduct part we are saying shall constitute a domestic violence if in case it is having four characteristics. So the characteristics in the section 3 has been told like any harm the person harms or injures or endangers the health, safety, threatens life, limb, well-being of the person, and whether it is kind of psychological, mental or physical, okay, including which is physical abuse, sexual abuse, verbal or emotional abuse, and emotional abuse, and economic offense abuses. So these all are category of the harm if the person causes. He can be said to have committed domestic violence, or person harasses, harms, injures, and endangers the aggrieved persons. The aim of this endangering or harassing the person is harming person is to coerce her or any person, okay, related to her to meet any unlawful demand. Unlawful demand. Suppose there is a Dowry Prohibition Act. Dowry has. So I said like you will go to the sections of uh, see like Indian Penal Code. Like hurt is there. What is similar kind of like bodily pain is caused, or any harm or danger to life is caused. Like mean grievous hurts are there. So grievous hurt has been given eight specific category of the harm can be designated as a grievous hurt under the IPC. So if such kind of like provision of the eyes, so they have given in detail eight emasculation. So that all because it also endangers the life. This kind of like abuses are happening, life or limbs are threatened, or health or impair the health or development of the every person. So health wise also person has to suffer, and which includes the assault, criminal intimidation, criminal force. So these all whatever was like is already been covered in Indian Penal Code has been given as a physical abuse to constitute the domestic violence. Okay, so that is there. So then there is something called what is sexual abuse, as given under the explanations are any conduct of sexual nature that abuses, humiliates, degrades, or otherwise violates the dignity of woman. As you are aware, there is for general offences there are section 354 outraging the modesty of women, and there is also Criminal Law Amendment Act of 2013, which includes many kind of voyeurism, stalking, and other offences. But we are here focusing this sexual abuse in the familiar relationship. So this is that's why domestic violence, protection of women from the Domestic Violence Act, it is called. So sexual abuse is covered like this. So verbal and emotional abuse in the act, as explanation says, uh, means any insult, ridiculing, humiliating, name calling, insulting or ridiculing, especially with regard to not having child. So the law has taken care of certain kind of practices prevalent in the society which are form of social evil. So like not having child can also one of the ground of stigmatizing or verbal or emotional abuse by the respondent, or not having male child also, child or male child, that can also be one of the, so that they have recognized there. Also repeated threats are there to cause physical pain to any person whom the person is interested. It can be like uh, any family member or other people whose like safety has been threatened, the threat has been given, so it will be verbal and emotional abuse. Then what is economical abuse? That mean deprivation of all or any economic or financial resources also is like they are entitled to that. If you go, Hindu Marriage Act is there, so there are certain rights are protected under because by virtue of the solemnization of marriage, having relationship as a husband and wife, there are some responsibilities of the spousal relationship. If that has not been like, mm, uh, the person has been deprived of such benefits, so this will be called as a economical abuse. Or any custom also demands that has to be completed, and like which the aggrieved person required out of necessity. So some of the necessity, like having uh, resources to pay rent, okay, having resources to purchase the groceries, these all are necessities. So that kind of things are not given. So household necessities, it can be for the aggrieved person, or children also are included. It's not only the aggrieved person or the wife only. For the children's substance also, that respondent is not giving, so it can be covered under the economic of abuses. And also, if any stridhan properties, because stridhan is exclusively for the use of women, uh, so that any emergency will not come. They see, or they will be having for their disposal, they can have. So if that is not given for, or any kind of like jointly or separately on, so payment of the rental and other maintenance also, so these all are deprivations, are they are not paying rent. So also, like alienation of the asset, I said some, because property as transfer of property act is there, which regulates that field. So there is something called property also has immovable property and movable property. So if some kind, because by virtue of that relationship in the family context, certain rights are created, uh, because husband's property, the wife has entitlement to use that. These all family relations, other relations also, because this act is not restricted to those only spousal relationship. Okay, so if that access is not given, so what will happen? Alienation of asset also will be considered as the one of the economical abuse. And also, like, by virtue of domestic relationship, person is entitled to use, but they have not given access to it, will be called economic abuse. Also, prohibition or restriction to continue access to resources entitled to use by virtue of domestic relationship. If that access is not given, the prohibition has been labeled like person is not allowed to use the resources, then that also will be economic abuse. So we have covered in this particular section what is explanation for those terms which we want to define as the domestic violence under section 3. So that explanations are like giving clarity, more clarity in the law, what the legislature wanted to tell. Okay, then there is chapter third of the act says about power and duties of the protection officer and service provider, etc. So I said because there are protection officers appointed under the act, so there are also service provider has been recognized by the state governments after due process followed. So so then there is a section 4 talks about information to protection officer and exclusion of liability of informant. So many informant or the complainant can come and they can give intimations, or they can give information about some alleged things are happening which are within the domestic relationship, domestic abuse are happening. So against the respondents. So these protections are needed to the informants. Unnecessarily harassing the that is not like in spirit of the DB Act. So Section 4 has taken care of that. It says in clause 1, any person who has reason to believe that an act of domestic violence has been or is being or likely to be committed. So the person has a freedom. Like it's not that after commission of the alleged offense only the person has a right to come to the police or the protection officer or the service provider mechanism, or to the metropolitan magistrate or the judicial magistrate first class. Even if there is likelihood, the person has right to give information. He may give information about it to the concerned protection officer. I said because all protections officers are appointed in the divisional like district level. So within the district there will be protection officers. So to give to them, And also, as I said, that person has been like in good faith. If someone gives information to the police, protection officer, service provider, or the metropolitan magistrate, there is a uh, uh, so section 4 talks about only with regard to information given to protection officer. So the person who is informant is protected. Okay, no liability can be fixed on him or her. Okay, so there are also duties of the police officer, service provider, and the magistrate. So what is duty a police officer, protection officer, service provider, or the magistrate? So I said these are the stakeholders in the implementation of the protection of women from domestic violence act. So in that case, the person like police officer, protection officer, service provider, or the magistrate who received the complaint of the domestic violence, complaint can be received, or the these officers, any of the officer are present at the place of incident of domestic violence, or the incident is reported to them in the normal course of their functioning. They shall inform the aggrieved person. Aggrieved person mean complainant. They will inform what. So there are duties given. So there are five things as given in the section 5 of the act, which says that of her right to make an application, that any like police officer, protection officer, service provider, or the metropolitan magistrate or the judicial magistrate of first class has to inform them, the aggrieved person, her right to make an application for obtaining a relief by way of protection order under the act, and monetary relief also order. Okay, a custody order or the residence order or compensation order, or more than one of such order, whatever is applicable in the case. So they have to inform her of their rights. And subject like clause B says that of the availability of the service of service provider. So there are service providers who has applied for that license. Okay, so now they have been recognized by the state government as a service provider. So availability of their services, the police officer has to inform, the protection officer has to inform, or for that case service provider themselves has to inform that there is availability in their organization which has been recognized by the government. Also availability of the service of the protection officer. So police officer can inform them like there are protection officers under state government's role whose help one can take. Also there are like there is article 39A of the constitution of India which says that free legal aid, like right of free legal aid. And there is a legal services authority act of 1987 which creates that there has to be free legal aid provided to the deserving one. And here the aggrieved person, because he's woman, so they are entitled to get what? They are entitled to get free legal aid. So it is the duty of the police officer or the metropolitan magistrate or judicial magistrate of first class, or the for that case protection officer or the service provider, that they can have free legal aid. They can go to any state authorities. Okay, they can go to any state authority. They can apply for what? That kind of they will apply for that kind of legal aid. From the legal aid mechanism there is empanelment of the lawyers. So from that they can go and simply make an application to the district legal services authority, or the state legal services authority can facilitate further. There are paralegal volunteers are there whose help can be taken, whose names are displayed in the legal services authorities websites details. So one can easily approach. There are service providers are working, so one can take also of her right. So because I said that this is wherever the relevant, there are other provisions like offenses in the marriage. Also Indian penal code has the detailed provisions. So there is a section 498 capital A of the Indian penal code of 8060 which gives certain provision for prevention of, like if you one will go directly, we can read the wording of 498 A of the Indian Penal Code, which is very easy to understand actually. So if one is like interested to understand what is for their benefit, I can tell you, because um, referring the law is very important in that case, um, when to get more clarity on the topic. So, so as I refer this section 498 capital A, so you can also in so there is a chapter 20 of the Indian Penal Code which says about uh, of offences relating to marriage. So in that, if one goes to section 498 capital A, so for that there is amendment. Chapter 20 capital A has been inserted, which says about cruelty by husband of the relative of the husband. So 498 capital A says husband or the relative of the husband of a woman subjecting her to cruelty. So this is the headline of the 498 capital A, which says whoever being the husband or the relative of the husband of the woman subjects such woman to cruelty shall be punished with the imprisonment for a term which may extend to 3 years and shall also be liable to fine. That is the provision. Explanation says what is the cruelty actually? Cruelty mean any willful conduct which is of such a nature as to likely to drive a woman to commit suicide or the cause grave injury or danger to life, limb, and health. So whether mental, physical of a woman. So that is one of the cruelty example. Another is the harassment of the woman, where such harassment is the view of coercing her or any person related to her to meet any unlawful demand of any property, valuable security, or is of account of failure of foreign person to related to her to meet any such demand. So